Now we were engaged, the committee will engage the witnesses in a series of questions, and the chair recognized himself for 5 minutes for the purpose of questioning the witnesses. Mrs. Toth, in your testimony, you discussed meaningful choice for consumers, and this is a principle that everyone agrees is a good one. However, it appears that the only choice for consumers using Yahoo is to opt out of receiving, quote, interest-based advertising, end of quote. It seems that they can't opt out of Yahoo's collection of information and tracking. Can you clarify exactly what the consumer's choice is with Yahoo's opt-out? If consumers ask to opt out of behavioral advertising, does your company continue to collect data on their browsing habits? And then I have another question. Does the opt-out only stop the displaying of targeted advertising, or does it stop the collection of data? Does your firm offer consumers any way to opt out of tracking and data collection? Would you answer those three questions for me, please?
Sure. So our opt-out, you're correct, it's not an opt-out of collection of data, it's an opt-out of use of data. So there are a number of reasons why we collect data, and primarily that relates to the display of advertising. So advertisers pay us to show advertisements, and so we have to know if those ads were delivered and shown. So we collect information in order to report that information back to the advertisers who are paying for those ads. But another reason why has a lot to do with the way we operate our websites. So if we were to stop collecting data when a user opts out, then there are a number of users we suspect would opt out and engage in behaviors on the site that may not be legitimate behaviors, that may be abusive or fraudulent behaviors. So we're continuing to collect information, but when the user opts out, we are no longer showing them behavioral advertisements. We are opting them out of that use of their data. So we are a website that offers a number of different services. Ad serving is one of our many businesses. So we have other uses for the data, as I described. So I'm not sure if I understood the other question specifically as being different from that one, maybe I misheard, but so to the extent that data is no longer used for advertising, that's what the opt-out applies to. But the opt-out that we offer is actually it's very clearly provided to users, and it is actually very easy to find. So we think that actually matters a great deal. The other thing actually that I'll mention is that what we offer on the back end is anonymization of that data within 90 days. So if users have a concern that there's a great deal of data being collected, we hope to be addressing that on the back end by anonymizing the vast majority of our data within 90 days. What's really notable about that is that our policy doesn't just apply to search log records or to a specific type of log file, but really all of our log systems, including the log systems that inform our advertising capabilities.
So a consumer cannot opt out of data collection at all?
The consumer can't opt out through the data collection.
They cannot opt out of data collection.
No, there are other tools at the browser level that would address that.
Sure.
For us, our systems don't work that way.
All right. Ms. Wong, can you answer the same questions for me?
Sure. Let me start by sort of describing our approach to privacy and data collection on our sites generally, because I don't know if you're a regular Google user. Google actually has a design philosophy of always trying to minimize the amount of data we collect about a user in the first instance. So almost all of our services actually don't require a user to provide any personal information at all. When you go to Google search, you don't have to register. You simply type in your search. If you type in a search and you're not signed in or registered with us, what that means is the only thing we get back is what all of us here, what all websites get, which is sort of a standard, what we call log line, that records a computer is asking you a question. And that question comes with two things that can be identifying of user. One is an IP address, which your ISP assigns to you, and the other is a cookie, which is what Ann referenced. Neither of those things for Google are tied to an individual. You can't know it's Nicole or Chris or Ann based solely on the IP address and the cookie. So just to be clear about the type of data we collect. We do provide an opt-out, as I was demonstrating in our presentation, for the use of that cookie and IP address data to target ads. In other words, when you click on the opt-out, what it does is, instead of getting a unique cookie, which is a series of numbers and letters, what you get is what we call the opt-out cookie. And that opt-out cookie literally says in it, opt out. So that the data that we collect goes into a huge pool of all users who have the same opt-out cookie. It's completely aggregated, which means we can't see an individual user in that pool of data that's been identified as opt-out.
The chair's time is up. The chair now recognizes the ranking member, Mr. Radonovich, for 5 minutes, and at the conclusion of his question and answer, the chair will relinquish the chair to the chairman of the communications subcommittee at the point in time.
Thanks. Thank you, Mr. Chairman, and welcome members of the panel. Your testimony is very interesting. My first question goes to Mr. Curran, is it? From your testimony, I understand that you're involved in a broad industry-wide effort to create self-regulating principles, and that these principles you're going to be releasing these principles pretty soon, I understand, within about 30 days. Can you expand a little bit on what we can expect you to address on those? And I'm particularly interested about the enforcement areas of these principles. You need to punch here. There you
Thank you. Actually, I think there are two different answers to your question because there are two different things going on. And in my long-form testimony, I detailed some of the work going on with the NAI in terms of our member companies, which are primarily advertising networks and other online marketing companies, to essentially further the development of technology that will allow, as Ms. Wong showed you with her presentation of Notice Inside the Banner Ad, really to get together to advance an infrastructure that would allow any entity serving a behaviorally targeted ad or any party responsible for a behaviorally targeted ad to deliver that kind of notice in connection with an ad. So that's work that the NAI has been pursuing from a technological perspective. Right. Separately, I think your question relates to a far broader industry dialogue that's been not led by the NAI, but instead by the IAB, the DMA, the 4As, the ANA, and also the BBB. That's a lot of acronyms.
That's much clearer now.
I think the key takeaway here is that certainly the FTC had indicated that broader self-regulatory approaches were needed for industry, and that is very much an effort in that direction of actually establishing principles similar in spirit to those of the NAI to apply on an ecosystem-wide basis. And my understanding is that the rollout of those principles is in weeks. And we're very much supportive of those efforts, and I think they are very much part of a trend of really a momentum towards exactly what the FTC called for in terms of really a very vigorous engagement by industry.
All right. Thank you very much. Ms. Wong, I'd love to ask you a question regarding your comments or support of establishing a uniform online and offline framework for privacy. Now, I'd love to have you clarify what uniform means, and does it mean that it should apply to all entities and engage in collecting or using and sharing online information, whether they are ISPs or application providers? Should it be straight across the board, or are there different applications?
Yes, and I think I have two answers to that. As an initial matter, Google and a number of the folks at the table here have been really working hard to think about federal comprehensive privacy legislation. And if I were to encourage the committee to do anything, I think it is backing something like that, because our history on privacy legislation has really been about sectorally trying to regulate privacy with children, with health, with financial, so that for a user on the internet, their internet experience is seamless. They go from their bank to their doctor to their web service seamlessly and don't realize that different privacy laws apply. the importance for ensuring that users continue to trust the use of their data on the internet is to have baseline privacy law across industries. And to get to your second question about...
Well, let me ask this so I clarify it a little bit. When you say uniform, does that apply to, say, content providers that provide content over Google? Would they be subject to the same uniform? Is that what you call uniform online privacy?
Right. So yes, that there would be baseline standards for all companies in terms of notice to users, access and control for users, and security for that data.
Okay, thank you. Ms. Toth, in Yahoo, recently you announced that it will be that you will completely erase IP addresses at the end of its data retention period, rather than just deleting a few numbers of its practice of, as is the practice of a number of your competitors. If you don't need the IP addresses for fraud prevention or anything else, what's the utility in keeping the IP address at all? And why the fractional numbers? Or why don't you just dump it right away?
So our, actually, I think we actually have slides in there of our data retention policy and the process steps that we take. So for the vast majority of our data, at 90 days, we de-identify the data. We apply a 4-step process to remove identifiers. Okay. The IP address is one of those identifiers that's stored in the logs. And that, for us, we completely delete that identifier at 90 days, with the exception of the fraud and abuse systems, which hold it for up to 6 months, and then it's deleted. So we store that data only for as long as we need it for the purposes of providing our services, and then we de-identify the records, and that gets to the IP address. The IP addresses typically, in the context of use, have more to do with customizing a user's experience along the lines of geography, those sorts of things. But it is de-identified and it is removed at 90 days. So
okay.
Does that answer your question?
Good enough.
Okay.
Yeah, thank you very much.
Well, I again want to express apologies to our witnesses for the lengthy delay. We were on the House floor a bit longer than we had anticipated, and you were very patient. We want to express the committee's appreciation to you for your willingness to stay with us and provide what has been some truly excellent testimony. I'm going to propound a series of questions and then recognize other members who are here. Some have made the point in written testimony, and I've heard it made otherwise apart from this hearing, that there can be a meaningless opt-in and a meaningful opt-out. And I would assume that the difference with regard to meaningfulness depends to some extent on the degree of disclosure that is made to the user. So what I would like is to get your statement of what you think the elements of a meaningful opt-out would be. Who would like to answer? Mr. Chester?
Thanks. That I think we need an opt-in. And my rule of thumb is that this has to be done in a doable way to make commerce work.
Well, Mr. Chester, before you alter the question and answer the question you wish I'd ask, let me see if we can get you or someone to answer the question I actually did ask. Ms. Wong.
I'll give it a try. I agree with you with the concept of, like, there are good opt-outs and there are bad opt-ins. I think a bad opt-in is, an opt-in slipped in a long provision at the beginning of a contract relationship with your user that they forget over time. And so there could be continued data collection in the life of your relationship with that user that the user's completely forgotten about. A good opt-out is an opt-out that's presented again and again to the user as a meaningful choice to them. So in our interest-based advertising, for example, one of the things that we are trying to do is to put ourselves in front of the user so that we encourage them to engage with their own data. That's the purpose of that Ads by Google link in the ad, because we want them to know when you're looking at this page, it's not just the New York Times you're looking at. The ad is from Google, and you should engage with that data. The purpose of our Ads Preference Manager is, again, to give the users a sense of control so that they change their behavior and start to engage and take control of their own data. And I think that
so you would make full disclosure to the user of what information is collected about the user. You would describe how that information is used once you have collected it, and then you would provide the opt-out opportunity.
That's right.
And would those be the meaningful elements of opt-out as far as you're concerned?
I think that's right. The continued engagement with the user.
All right. Now, let me ask Mr. Chester, who I know is very interested in taking part in this discussion, what his response to that would be.
Well, my rule of thumb is this, but it has to be done workably. The companies should be telling the consumer what they tell prospective clients. Because when you see and I included some of that in my testimony, when you see what they are telling their clients and their prospective clients, or when they're reporting on the results of the data collection system they've created with the advertising, they're talking about a massive collection of data that's far beyond the kin of what might be presented in a simple opt-out. So they need to be honest and tell people exactly what's about to happen. It can be a scale here, but if you read what they are doing, and including, frankly, the companies here, if you read what they're saying, and also how the applications, the interactive applications, when you read the literature, the interactive applications have been designed, the online video, to get people to give up more data. So they have to be honest at first.
All right. Thank you very much. If we were to draw a regulatory line of some sort that is focused on the collection and use of personally identifiable information, should we include within the definition of what is personally identifiable information the IP address? Mr. Chester's saying yes. Let me see if any have any different views. Everyone agrees that, well, okay, Ms. Wong.
I'll give it a try again. I think our position is that the IP address can be personally identifying depending on your relationship with the user. So for example, if you are the ISP that assigned that IP address, what it means is that you are actually billing that user every month and having credit card or billing information from them, which means you can in fact associate the IP address you as the ISP assigned with a real person. If you're in a position like Google, where with an unauthenticated user, where you don't know who is attached to that IP address, it's not personally identifiable.
So you're saying it would be personally identifiable if it is associated with other kinds of information about the user.
That's right.
Some of which might be quite sensitive and personal.
That's right.
You would probably say it is not personally identifiable if you have that in isolation, perhaps with an opt-out cookie.
Right.
All right. I think I understand your position. In the time I have remaining, let me ask about the possible role that self-regulatory organizations might play in a statutory scheme that would extend privacy rights to Internet users. Several questions about that. I know we have well-regarded SROs in existence today. Many of the major Internet companies are affiliated with one or more SROs. And I'm concerned if we add a statutory scheme on top of that in order to assure that every Internet user has the understanding that his online experience is secure, because all websites will have to comply with a certain set of fundamental privacy assurances. How we do that in association with continued viability and usability for the SROs. So just a couple of key questions. How would a user who feels aggrieved because the SRO, for example, may not have complied with the principles it signed up to comply with, get recourse? Should there at some point be access to a federal agency to seek that recourse? And how could we make sure that every website actually complies with a minimum set of guarantees? So who would like to try answering that? Mr. Cleland?
Well, I think, you're trying to get to something that actually works, and I think you're trying to get to an accountable system. One idea I would offer that, whether it's self-regulatory or governmental, is that there needs to be some audit that is occurring on a regular basis. Those can be automated audits, or they can be personal audits. They need to be random, because what you're talking about is meaningful. We're talking about accountable, And if you care about those two words and those two concepts and principles, there needs to be some verification.
All right, other comments, Mr. Chester?
I guess, there's a role for self-regulation, but I just have to underscore that self-regulation has failed. The only reason the NAI is upgrading its principles was because of the controversy that occurred over the Google DoubleClick merger, when all these consumer and privacy groups made so much trouble that then the FTC said, okay, we got to do something about privacy principles, and then the NAI, after many years of being asleep, decided, okay, we're going to revamp them. The only reason the companies have reduced their retention time is because the European Union has been pressing them. So it's the forces of regulation that's actually bolstered the failing self-regulatory system.
So you would agree, would you not, Mr. Chester, that if the statute imposed certain fundamental guarantees and they meet your definition of what those fundamental guarantees of privacy should be, for example, that an SRO that then enforces those fundamental guarantees or has those as its core principles that are a condition of membership, such an SRO could be effective, could it not?
I think the history of self-regulation, certainly in media and telecommunications, like in the kids area, has been that the self-regulatory structure is only as good as the law that has, in fact, within the foundation.
On that note, my time has expired, and I'll recognize the gentleman from Florida, Mr. Stearns, for 5 minutes.
Thank you, Mr. Chairman, and let me also reiterate your comments. This is the first time, I think, in the history of Congress that we had this kind of procedure on the floor. We had over almost 55 votes, and they were over almost 8 hours, and so you have hit sort of a perfect storm, so your patience is appreciated, and we appreciate you staying. Ms. Toth and Ms. Wong, any given day, people come to your sites. Let's call that X. They all come to your sites. How many of those, what percent of those people actually go to your privacy? Ms. Toth?
We don't calculate it as a percentage. Overall, the number of page views of users who come to our privacy policy remains a fairly low number overall.
So and let's say just take 1,000 people, just to make it easy. 1,000 people. You couldn't even tell me if it's 10% or 1% or half a percent.
It's certainly far lower than 1%.
Yeah. So it's very, very small. Mm-hmm. And Ms. Wong, about you?
You know what? I don't know, and I can try and get back to you with a number, but off the top of my head, I don't know the number of views.
No one on your staff can just even give a ballpark? I mean, it's not 10%.
I'm sure it's lower than the number of overall visits we get. Here's what I do know.
Yeah.
Which is that a year ago or so, we started uploading videos to explain our privacy practices.
Yeah.
And what we're seeing there is that users are engaging with us in those videos.
Because it's a video. Okay.
Because it's a video, and they're rating them and telling us what works for them and what doesn't. And I know that notice is a really important thing for this committee. We have to find better ways than a pure privacy policy to engage with our users to make them
And
care.
videos might be a good way.
And videos
now,
might be a good
each
way.
of you mentioned that you are willing to give to the consumer the information that you have collected and give it in sort of in categories. And is this information that you're going to give, this has been synthesized, or you have put together a summary and given it to the customer? Will you let the user actually see your raw data, or at least actually see what you collect? Will you ever allow him get to the point that they can actually see what you collect?
I would actually love it if we could. I'd like you to see some of the data that we actually do collect, because I think it's.
So I could actually see it if I wanted to,
right,
and not just get your categories or.
Well, we have a slide that that shows our log files, or a sample of what we collect in the log files. I don't think actually a consumer would engage with that in a way that would be meaningful for the consumer, because it's a very technical expression of a user's interaction with us on the site. So what we do in our behavioral, in our interest-based advertising and the behavioral targeting systems that we use is to take those visits and categorize them based on the types of interactions. So if a user visits sports, they'll have a score that indicates they visit sports. The actual log files themselves would probably not be useful for a consumer to engage with. It's a series of it's actually quite difficult to explain in plain English what is in a log file for a lot of people.
Okay, but the customer would have access to is what you're saying if they wish to.
Well, the customer, we don't actually make it available because there are no tools that actually generate log files in a way that would be easily accessible for consumers. What we give consumers is ready access to our privacy policy,
Okay.
educational links, opt-out opportunities that are abundant across the site.
So if, I mean, like, the demo that we did for you about our ads preference manager is an attempt to make that interface real, right? Which is demonstrating the interest categories that are assigned to a cookie in order to target advertising. Because I think Ann is correct that if a user won't read a privacy policy, they're surely not going to read code.
No, okay. Mr. Chester, before you can answer that question also, what do you do with the bad actors? I mean, we sit here and we pass a bill and we set up opt-in and opt-out procedures, and we've got Yahoo and Google. Well, what are you going to do with the bad actors, and how, I mean, is it possible that in addition to developing this legislation so that all 50 states have one set, because each state now is developing a different, and so there might be a need for us in the federal level to develop it so you don't have 50 states with 50 different privacies. So I guess my question is twofold. What do we do with the bad actors, and is it a possibility that you could set up good housekeeping seals that everybody would say, I'm safe with this site, bingo, I can go into it and feel comfortable, and the bad actors wouldn't get it, and then you could differentiate and say, I'm not going to fool with those?
I think if you passed the legislative standards, right, that would be the baseline. Everybody would know, basically, they're protected. You now have a changed FTC potentially, and hopefully you're going to reauthorize it soon. I mean, the FTC has been hampered in going after the bad actors. It's been constrained from really looking as closely at this market as it should be. It hasn't had the resources, and it's also been in conflict. There's now a new chairman there. There's a new director of consumer protection. They really want to move on this issue, and they could, in fact, be empowered to go after the bad actors in a much more vigorous way. Of course, we don't want to see state preemption, consumer advocacy. We want to let
I understand.
States.
Now, when I had hearings on this when
Yes.
I was chairman, one of the problems we found is that there was no reciprocity between countries, and you had the bad actors outside the United States. And so part and parcel of this is develop legislation with other countries where you have reciprocity so you can go after corruption and fraud, and there is that ability to do it. Otherwise, no one's going to comply with the federal bill, and they'll be in another country.
Well, I do think we're falling behind the Europeans, and it's something ironic. They're going to have better privacy policy and build a whole new online commerce business that's privacy friendly while we're lagging because they're moving. Look, there's a lot of the market is really being shaped, and this is something positive about the industry. We're creating this global interactive market.
Right.
Yes, there are European companies. Yes, there are Asian companies, but they, in fact, have created the standard, and that is terrific. What happens here can shape the rest of the world. As for profiles, you can see company after company says, I have all this information about an individual consumer. I would hope that under your legislation, that consumer could see all the detailed information that's being collected about them.
Mr. Cleveland?
Yeah, I think if Congress is serious about this, you need to focus on the concept of deterrence. I mean, if privacy violations or repeated violations are important, there needs to be a significant penalty of whatever is appropriate. But if legislation is passed and there's no deterrent and there's also no significant way of getting caught, meaning independent audits of some type, it will not have teeth, it won't be meaningful, and it won't be accountable. So I really, if you're serious about this, you really need to be thinking about how do you take unaccountability, which is a problem across the internet, not just with privacy, and try and address that and create more accountability. It's never going to be perfect, but it's a key.
Mr. Chairman, if you'll give me a little slack here, I just want to bring this last question, which really is also we as legislators are grappling with, and that's the regulatory side versus the enforcement. Mr. Cleveland talked about the enforcement. And we have two jurisdictions here. We have the FCC and the Federal Trade Commission. So I'd like to just start to my left and just go down. And perhaps you could give us a feeling of how you think this bill should come together in terms of jurisdiction with the FCC and the Federal Trade Commission. I mean, some people think, well, the FCC could be the enforcer and the FTC could be the regulator, but I'd be curious, each one of you, if you don't mind, take a few moments, Mr. Chairman.
I would see this as closer to an FTC issue I think it's fundamentally a consumer protection issue.
So both for regulatory and enforcement?
Yes.
Okay.
I would agree with Mr. Felton. We've worked for a very long time with the Federal Trade Commission on issues of consumer privacy online. We feel very comfortable and believe that they are well-versed to address this issue.
Ms. Wong?
I have to say I feel a little bit out of my depth in terms of understanding jurisdiction between federal agencies, but like Ann, and we've worked for quite a while with the FTC. My experience in watching them over the last 10 years is they've brought very effective enforcement actions.
I would say as well that we've worked extensively with the FTC so far along this, and they also have a great deal of expertise in the competition area, which is one of the things that's driving better technology throughout the industry in terms of providing users more transparency and more control over their data. So the FTC has developed a great deal of expertise in this area.
I'd like to see a joint task force because, in fact, the FCC will have expertise at the network level, and particularly with cases with DPI, deep packet inspection, there's a real role here for the FCC. But when it comes to the ad itself and the data and the consumer experience itself, it's the FTC.
Yeah, I mean, because, you know, this is going to envelop, once you get broadband more, you're going to see voice over internet, you're going to see everything over the internet. And so all communication is going to be through that media. And so, you know, I think the FCC has a part and parcel role. Mr. Curran?
I think I'd echo the nod to the FTC. Certainly in terms of our business model for cookie-related activity, the FTC for over a decade with its workshops on the technology has been instrumental in raising awareness of the policy and technical issues and very much a determinant of setting the direction for self-regulation. And as for other business models and other regulatory schemes, I wouldn't be able to speak to that.
Okay, Mr. Cleveland?
FTC is a lead in close coordination with the FCC. The only problem would be is if jurisdiction got in the way of passing, if you want to pass legislation. That'd be the only tragedy.
Yeah. Thank you, Mr.
Thank you very much, Mr. Stearns. The gentleman from New York, Mr. Weiner, is recognized for 5 minutes.
Thank you. Could I ask, perhaps for Ms. Wong, to talk a little bit about your experience developing Chrome, which is your search engine, what's it called?
Browser.
Your browser. Wouldn't it be possible through that vehicle to, when you download it, get your first page is, tell us what information you'd like to know about the pages you're visiting and what information that you'd like to share, and maybe a collection of boxes you can check or not check. It's similar to kind of what Facebook tries to do, although they don't do it right in your face. They kind of have, you can shave this, not that. That seems to be even a better place to think about the true gateway to the experience. If I wanted to do that through Chrome, would I be able to do that in some way? I mean, I know I can go and erase the cookies and I can erase my browser history, but can I do something like that?
Right. Thank you for that question.
You're welcome.
And I'm a little bit at a disadvantage because I'm not an engineer, just a lawyer. And our engineers do amazing things. I think that, so I don't know that there's any limitation on what they can do. I know they're working very hard to build privacy controls
Well,
into
perhaps
Chrome.
if I can interrupt you, maybe Mr. Felton can tell me about the technology possible here.
Sure. The information flows that users might be concerned about mostly happen not at the browser, but after the user has interacted with a website or a content provider. So what that means is that technical controls would exist mostly not in the browser, but in the websites themselves.
But let me interrupt on that point. But if you have a fairly finite number of browsers that most people use, let's say for the purpose of this conversation it's 5. You know, I don't know. I mean, that basically probably accounts for most of what people do. And the browsers are themselves competitive with one another. You know, you can argue that the browser industry grew out of people's dissatisfaction with Explorer. So why couldn't you say that if you want your website to come up when you're traveling through Firefox, you have to have certain of your own information that you're giving us about what we can tell our users? Isn't that kind of a technical solution, a solution, but a technical way to kind of serve as a gatekeeper for a lot of websites?
Yes, and certainly there are things you could do along those lines so that the browser could help the user express their preferences, and the browser could, in a technical way, query a site and see what promises the site makes about uses of data. There have been efforts to do this in the past. There was a standardization effort called P3P, the Platform for Privacy Preferences, which defines such a standard, and for reasons that are a subject of debate, the standard didn't stick. It wasn't popular. Nonetheless, I think this is a fruitful approach, and I, for one, would be happy if the companies got together and had a discussion again about how to do this.
Mr. Kelly, tell us a little bit, if you could, about your experiences in stepping on the toes of people's privacy concern. I mean, it seems to me that we, to some degree, have three companies that have succeeded because consumers with a lot of different choices have chosen to use Google, chosen to use Yahoo, chosen in large numbers to go to Facebook. Could it be that the reason they're choosing your three services in particular is that you're being self-selected by an active consumer marketplace that thinks the privacy works on your sites? Now, you just had an experience, I guess it's an ongoing one, where you've had a kind of a conversation with your members about privacy. How does it work differently on yours than, say, what search engine do you use when you're searching the internet?
I mean, it's usually Google.
Okay. How is your privacy experience as a consumer of Google different than as a member of Facebook? Is it at all?
Well, I think that all three of these sites have succeeded because they're providing great user experiences overall, and in some cases those are around privacy. And because we've based a business on identity and personal information and the effective sharing of that with people who share a social context with you, we knew going in that privacy was going to be a critical issue for us. And our goal has been to build technologies that allow people to make choices. So one of the things that's gotten lost in a lot of the mix in the discussions of social networking is that friending, whether you friend somebody or not, and how you connect to them is in and of itself a privacy setting. It determines what information that you see on Facebook, and that's been a great experience for us. When you look at a Google or a Yahoo as a search engine, they're looking to deliver a different experience there. They're looking for you to type in a word or two and get back something that they think is the most relevant experience for you, to get you to the page that you need to go next. If you use other services on those, on those sites, they're providing different experiences there. Our goal has been to build technology that empowers users and lets them make their own choices about how they share information. We've aimed to extend that into the advertising realm as well.
Mr. Chester, I know you want to answer this question, but let me build on it. You can go ahead and for my last few seconds you can answer. But take me back to 1986 or even 1996. I don't even know when this phenomenon all began. You could buy someone's credit report from three different companies. You could probably find aggregators of information that help car dealers figure out who to send their information to. You could probably scrub public records to find out what kind of a home that they own, how much taxes that they pay. It seems to me that there have always been resources that allowed someone to do 75% of what you described in your testimony as the thing we're protecting against. And we've acted here in Congress to try to limit access to that information. But to some degree, wouldn't you agree that consumers have pretty much now have a lot of tools that inform their experience? I would argue, without even knowing it, I bet you there are places I can go on the internet to even find little software plugins I can probably download to let me know who's doing what with what websites are good or bad at protecting information. So it's a two-part question. One, isn't a lot of the stuff that you're most concerned about going to be out there whether you don't plug into the internet at all? And secondly, isn't to some degree the marketplace aren't consumers allowing the winners to be the good privacy companies? So why don't you take both pieces?
Polls after survey, including the one that UC Berkeley just released about a week ago, 10 days ago, say that the most consumers have no idea about what's being collected, how it's being used, how it really works. I honestly believe, and I think this is going to come out as part of this debate, and frankly, that's why we need good privacy legislation, because it's going to undermine public confidence. people don't really know what's going on inside Facebook and the third-party developers and all the data flowing out. They don't know what Google is collecting across its various interests. If they knew, they would, in fact, I think, be more concerned. So consumers don't know. The polls show that. This is a whole different world here, right? Than it was back in 1996, 98, when we did the Children's Act. You're talking about the instantaneous merging of a vast number of offline databases with online behavior, minute by minute, that is adopted to an individual's actions and reactions with various online environments, including all the personal information they put on their social networks. This is a completely different system that's been created. And finally, you know, I mean, I have a 16-year-old. I look at this as the world that will be here very soon. We will be buying our mortgages on this mobile phone in a not too distant future. This is the dominant way we're going to be doing business, through the PC and the mobile phone. It's a whole different world that has been created. On the one hand, we should be proud of it. They created it for us. We just have to make sure that consumers are protected.
Thank you, Mr. Chairman.
Thank you very much, Mr. Wiener. The gentleman from Louisiana, Mr. Scalise, is recognized for 5 minutes.
Thank you, Mr. Chairman. When we talk about opt-in versus opt-out, and I would imagine for business model purposes, opt-out is the preference, because if you force somebody to opt in, I would think it would probably limit the number of people that would want their data to be collected on the front end. But if they do go through the process of opting out, are they actually stopping their personal data from being collected, or are they just not getting the targeted advertising? And then if Ms. Toth could start.
When a user is opting out, for us that is an opt-out of not collection but of use of the information. But I also want to be careful about the use of the term personal information, because very often what's being conveyed to us is information that's specific only to a browser that's used to customize advertising. But even that level is what the user is able to opt out of in terms of that data being used.
Right, and there are different levels, of course. If you're just going onto a browser, and I think Ms. Wong talked about that, if I just go on to Google and do a search, there's different information, maybe just my IP address, but then if I actually use Yahoo for an email account, then clearly I'm going to be giving you a whole lot more information, and then you'll have access to that. And if I choose to opt out of that, what am I opting out of there? Are you not going to be collecting that data anymore, or are you just not going to be giving the targeted advertising?
So the way that we do it at Yahoo is that when a user opts out, we are no longer showing them targeted advertising, and we're not using their information in that particular way. Yahoo offers a wide array of products and services, as you mentioned, email, search, a wide array of different
maybe social network services.
Some social networking, exactly. So when a user opts out, we opt them out of the delivery of targeted advertising. But we also recognize that users may not want us to have that much information about them. So we take great pains to de-identify the data as soon as we can. We spent over a year looking at every single product, every single data system at Yahoo to really try to minimize the amount of time that we hold data about users.
Right, and I know we got limited time, so Ms. Wong and then Mr. Kelly.
Sure. I think it's roughly the same answer that I gave earlier, which is we really collect very little data from users when they're searching the IP address and the cookie. And the opt-out for our interest-based advertising is an opt-out for those targeted ads. And what it means is that the cookie you're getting is not uniquely identified. It just drops the query that you sent us or the data that we've gotten into a bucket of all opt-out cookies.
So, and because our service is based on sharing personal information with others, we inevitably end up collecting a great deal of personal information so that we can effectively share it with others and actually use people to retain retain people's photo albums for them, which they usually expect to be retained indefinitely. In certain circumstances, and particularly in our advertising products, where we're innovating and where people may not be used to a presentation in a particular way, we've allowed for opt-outs in those instances because we think it empowers users. It allows them to say, I'm not comfortable with this at this point, but they can reconsider that at a later time. Our goal overall, and I think the goal of this committee and any legislation it considers and any enhancement of regulatory authority, should be to make sure that consumers have real power to make those choices. We've tried to embody that in technology as much as we can, and you're here trying to embody it in law and trying to encourage the regulatory agencies to continue to meet their burdens and their obligations under existing law.
And I apologize to interrupt. I've only got a minute left. There is something else I want to ask, especially as it relates to the email services, and both for Yahoo and Google, if you can answer this. If a user of Yahoo or Google or any other email service decides that they want to opt in or they don't opt out to all of those agreements, and you can collect whatever information you want from them, but let's say they then send me, and I don't have that service, and they send me an email. I didn't agree to any of those issues. Do you read emails from people that are a Yahoo or a Google email subscriber? Do you read through those emails to gather information in any way?
Yahoo does not scan the content of email communications in order to show targeted advertising.
Or for any other purposes?
We don't show, well, there are only some purposes for, there is a process that actually removes viruses from email. That's an automated process, but we don't use the content of communication
For advertising. Ms. Wong?
Yeah, so we're using that same technology that scans for viruses and also scans for spam. It's basically technology that looks for patterns in text. And we use that not only for the spam blocking and the viruses, but also to serve ads within the Gmail user's experience. So importantly, like
So if two people are exchanging an email about a sporting event, and they're talking about going to the game, and then maybe they're going to want to go out for a drink afterwards, could they maybe then expect to get an advertisement about which different bars are offering specials after the game?
So they won't get an email with an advertisement, but for a Gmail, only the Gmail user will be able to see ads that show up just like they show up on the side of our search results that are keyed to specific words. They're keywords just as if you typed them into our browser that are calling from our repository of millions of ads to deliver an ad that's targeted to the content that you're reading.
So if that was a two-way conversation, one was the Gmail subscriber who agreed to or didn't opt out of the privacy, but the other person in that conversation was not a Gmail user, clearly not someone who opted in or opted out, would any part, because in an email thread, they could have had maybe 4 or 5 replies, and you've got a long thread built up, and it's not just going to be the Gmail's information that's going to be there. The person who's a non-Gmail user is also going to be included in that thread. Would any of that information be read?
Non-Gmail user will not have any ads targeted to them at all.
Is any of their data collected from that conversation?
Their data sits in the recipients, the Gmail recipients' email archive.
So if you've got algorithms that went through that Gmail email, then when you were reading things in that email, some of the things that you were reading would have been part of the thread of a non-Gmail subscriber.
That's right.
How does your privacy policy handle that? Because that person clearly has absolutely no knowledge of you reading their email. They surely didn't agree to it, and they didn't have the ability to opt out. So how is that handled?
Yeah, just to be really clear, there are no humans reading email at our company.
But even if it's a software algorithm that's trained to go through and look for keywords or key information, their email address, of course, is going to be in there, so you would be able to know who that person is, at least from their email address. But also you would be able to have access to the information. Do you have anything in those algorithms that prevents that information that's not Gmail related to be read from a person who didn't agree to or have the ability to opt out of your privacy?
It would have to be that the user decided they did not want to receive that email from the person who sent it to them. So this is fully in control of the Gmail account holder, and they can refuse to receive emails from certain people.
So you would be putting the burden now of privacy collection on a user of Gmail? Someone who actually has a Gmail account?
So our user...
But your user actually knew what your policy was and
Yes.
could today, right now, go online. As you showed, you've got many opportunities for your users to opt out.
That's right.
The person who's the third party, who's the non-Gmail subscriber, who's part of that thread, does not have that same access. So how how can you put the burden on the person who sent the email?
No. The person who sent the email they have sent their email to their friend. That user is not going to get any ad targeted them. We're not going to have any information about that user.
But was
at
any of
all.
their information
but
read?
for the fact that we hold their email because we're the email service provider for the Gmail account holder, which is the same as any other webmail service.
And I guess the real question is, how is that person, the Gmail subscriber clearly has the ability to protect their privacy, to opt out if they so choose. Maybe some of their data is
By
still
not using
collected,
the
but they
service.
could opt out. But the third party that they sent the email to, who then replied back to them, who's contained in that thread, doesn't have that same ability, but yet their data is subject to being searched in the same way. And I guess
that's true, but that occurs with every webmail service because every,
but I think Yahoo
every
just said that
webmail
they
service
don't do the same
scans
thing.
their email.
I'll ask Ms. Toth if is that?
Every webmail service scans their email for spam, scans it for viruses. It is the same.
But also for
process.
targeted advertising. I think you said y'all do scan it for targeted advertising. Ms. Toth said they do not.
We do not target, we don't.
And I guess in the case where they are scanning it for other services that would be maybe sold to a third party, how does the person protect their privacy when they never had the same opportunity to opt out that the original Gmail subscriber who sent the email was able to have the same access?
To be very clear, no user's information is sold to any third party. No information about the sender of an email to a Gmail account is kept.
Well, but if double click
Mr. Squeeze, you're now past
time.
10 minutes of time, and we're going to wrap up.
Yeah, if I could get that in writing, maybe the answer to that. Thank you.
That's fine. If any of the witnesses would like to respond to that last question in writing, that would be highly appropriate. The gentleman from Vermont is recognized next, Mr. Welch, for 5 minutes.
Thank you. I want to join my colleagues in apologizing for our delay and appreciation for your patience. Although I think I might rather have your job today than ours. Ms. Wong, in your written testimony, you noted that the committee should continue our efforts to explore the privacy issues. I mean, this is obviously an incredibly difficult issue, both because of the complexity of making this work and assuring confidence to users, and because of basic questions about what should be private and what isn't. I'm asking that you expand on that, and what ongoing efforts is Google making about the merging of online and offline data and the issues that are created as a result of that. So I'll start by asking you if you would comment on that and probably ask a few others as well.
Sure, and I actually think this is a multidimensional question. I think absolutely there's an obligation on industry to do the right thing because the trust of our users is incredibly important. I also think that there's a role for groups like Mr. Curran's group, the self-regulatory groups, which continue having us innovate on best practices. I think the best thing that has happened in the last few years is that all of the major internet companies are competing to create better privacy technologies, and that is really phenomenal. There is also a role for government because, to be very clear, there are bad actors. And so there is a role for oversight into the range of players on the ecosystem and the conduct that they engage in. And the thing that I think is most important, and the reason it should apply to both online and offline, is that the companies that you have here all face our users, are all invested in deepening the relationship with our users. There are companies that do not face the public, that are behind it, and that need more oversight because nobody knows what they do with their data.
Mr. Curran, you want to comment? Do you have anything else to add? I mean, that's a kudo to you for the role that you play.
I'd simply say I think we have an obligation to tell you about our successes and our areas of improvement as self-regulatory organizations as it relates to, and also to, I think, to work with you to explain the somewhat complicated technologies that go around the different business models. I don't believe that I have a diverse membership so that we're not at a position of having a legislative view at this time, but we are very much committed to educating the committee on the technologies, and I think today's hearing has been very helpful in that, in terms of, in effect, helping you discern the exact technical infrastructure that goes into all of this online advertising.
Well, let me come back to Mr. Kelly. You know, the Congress is never going to be able, obviously, to address technical issues. It's not our competence, it's not our job, it's not what we should do. What specific things in terms of policies, I'll ask you, Mr. Kelly, would you be recommending that Congress do in order to protect privacy, which is our proper concern, but do it in a way that doesn't strangle innovation?
And that is a critical role that you do have, is to protect the innovation in American technology and how we've been able to lead the world in this area. But obviously, protecting the privacy of American consumers it's critical to us and to other companies in the technology industry, but not everyone. Mm-hmm. And so there are many actors out there who are tasked and see their role as gathering data and building personal profiles of people with no notice, no consent, no control. I think that the Congress's regulatory action should be largely directed there. We have a set of existing and extensive regulations, and we've talked tonight about our work with the FTC as a technology industry in this area where there are bans against deceptive practices and other activities, but still there are many technology companies out there, whether they be spyware vendors, whether they be just surreptitious collectors of and aggregators of personal data that deserve the attention of this committee, the Congress, and existing regulators.
Okay. Thank you. My time has almost expired, and I'll yield the balance of my time.
Could I answer?
Up to the chairman. I think I'm almost out of time.
Yeah, that's fine. Go ahead, Mr. Cleland.
Yes, I think the key concept of what you're looking for is that the FTC and others should build on is longstanding fair representation law. We obviously have a huge gap. Jeff mentioned a lot of the polls out there. Consumers don't have a clue about all the stuff that's being collected on them. Not a clue. And so if you believe in fair representation and you take the facts of all the people that have been dealt with in the internet and they don't know what's going on, there is a serious breakdown in fair representation.
Mr. Chester, please.
Very briefly. All the companies here, including the members of NII, as far as I can see, are increasing the amount of data they're collecting on consumers, right? It's not that there's a question of best practices. They are building and expanding the data collection. That's the nature of the business. That's the nature of the online advertising system, to build out these very sophisticated approaches. Therefore, you need to have rules. You need to bring PII up to date, because you don't need to know your name anymore to know who you are. You need to protect sensitive data, and you have to have the FTC be a better watchdog.
With that, Mr. Welsh, your time has expired, and let me say thank you once again to our witnesses for what truly has been an informative session. Long delayed, but well worth our time talking to you, and we thank you very much for taking your time all day, in fact, to talk to us. I have clearance for unanimous consent from the minority to place in the record a letter to the subcommittee, the joint subcommittees actually, from the Federal Trade Commission concerning the subject of today's hearings, a letter from Data Foundry, a data company based in Austin, Texas. Without objection, those will be made a part of the record, and without objection, the record of this proceeding will be kept open for a period of 3 weeks so that other members of the subcommittee can submit to our witnesses questions in writing. And as you receive those questions from the members, if you could respond to them promptly, that would be much appreciated. Well, with thanks again to you for an excellent hearing, this hearing stands adjourned.